train people that are building the startups and building the legal technology that we're wanting, whether it's within a law firm, whether it's a startup, et cetera. And this is cross-disciplinary work, so we're going to look at a lot of issues in terms of getting this working. A quote from Susskind that we can't just put a lawyer and an engineer or a designer in a room together and hope that we get a good legal product. So what we really need to do is be doing some degree of cross-training so that the people are really ready to go out and make the changes that we're looking for. So within the program, sorry, that slide got lost, founded by me and Margaret Hagan. Unfortunately, she's doing another event, so she can't be here right now. It's an interdisciplinary program that involves, right now, the law school and the design school together. And then, as I'll describe, we bring in people from other fields. We're looking at education, service, and research. For the education component, it's things like courses that many of us are used to around, at this point, legal technology, but this is, I'm not talking in this case about practice management technology, but really some of the deeper issues that we look at, like the role of automation in law, how to look at law as an information flow. So for example, what data comes into a law firm? How is it transformed? What data goes out? It's looking at legal problems, looking at legal formulas, and trying to revamp that to, just to check data flow. So another thing is having students be able to recognize the technologies that are out there and to be able to apply them to legal problems. So a lot of issues there, like the role of search as something in a technology toolkit, would show up, whether it's in matching lawyers to clients, whether it's in patent law, et cetera. I only have 10 minutes, I gotta go. The other thing is the design workshops, and in particular Margaret Hagan has been spearheading this effort, where we've brought in groups of, it's lawyers, engineers, business people, designers. We put them together in these small teams. They go after problems like, how do people know where they are in the immigration process? This is not about changing the statutes. It's really about, for example, putting an interface to the legal system that is manageable and understandable by people. Estate planning, plea bargaining, bringing in prosecutors, public defenders, et cetera, and getting them in this to interact with students and experts in the field to see what kind of designs we can come up with to make the process more transparent, to increase procedural fairness, et cetera. We're trying to get technology and design savvy lawyers, as well as bring in engineers and designers that are more aware of the legal issues around it. From a service perspective, we're coming up with new user-centered designs, which the law has really been lacking. The interface to the law typically is the lawyer. And we're looking to see how we, as we see more consumer law, we see more things coming online, and people here have been doing this for a while, client-facing software, et cetera. How do you make that as friendly as possible? Also looking at legal requirements for legal functions. So we're starting to look at, okay, something as easy as e-signatures. What are the core legal requirements for e-signatures where we need that understood so that we can re-implement it with technology? Why can you sign something now e-signature-wise, but you can't do witnesses? So what is it that are required by witnesses that's so hard to implement online, for example? But we go through and what are the requirements around dispute resolution? What are the requirements on and on? E-discovery. We'd like to move towards doing prototype implementations. We want to work on things like standards. Now, there's a lot of standards that are coming around, so people are aware of things like document standards, XML, et cetera. But I'm also looking at things like, how do we measure quality? When we have a panel of people that are talking about bringing down costs or gains in efficiency, moving small claims, for example, to just, online dispute resolution. How do we measure the quality of any service that we're providing so that we know the trade-offs between the gains in efficiency and the quality of the service? Dispute resolution can be resolved by flipping a coin. That's very efficient. The quality is missing, right? It's an extreme example. Standards. Also, how can we provide a pipeline of technologists and startups. So for example, after we're done with the design class, our goal is to move to getting the design kind of startup launchpad process working specifically for legal technology startups. And finally, third-party neutral problem solving. I'll get into an example of that in a second. And then lastly, the third prong is looking at research. Here we're working with the Center on the Legal Profession. Deborah Rohde will be speaking later today. Lucy's here. Looking at consumer law. What is the behavior? What do they expect online? How do we tailor these consumer systems to match what people's needs are? Quality metrics, as I said, legal requirements. What is the issue around injecting innovation in big law? You can't just take some new technology and throw it into the mix. Often you need changes in business models. There are key decision makers, as I mentioned before, that have interesting ideas of what software should be developed or how that should work, and it doesn't always work. So it's worth studying, taking something like Innovator's Dilemma, Christensen, and mapping that into the legal space so we can really figure out how to transform big law. For example, producing more per dollar so that you get the same amount of dollar spent, and looking at the return on investment among the clients so that they don't want to stop spending money on legal services. We're looking at increasing access through technology. I know that there's been tons of work on that, and there's a panel on that later, and Stephanie Kimbrough's here, and she'll be speaking about some of this, but that work's going on where we're looking at how do we pool a bunch of resources together and make it available. So in this sense, what we're wanting to do is throw the design process in as well to look at directors, for example, of legal aid clinics and find out what their problems are so that we're starting to build solutions to real problems rather than arbitrary solutions. And then, again, Stephanie's working on using games for consumer law as a way of learning, and she'll talk about that later. One thing I want to highlight is Stanford has some unique strengths. Being in Silicon Valley, the way that the entrepreneurship kind of permeates campus is really conducive to some of this work. So as an example, one of the things that we're working on now is looking at how to streamline startups, pilots in large enterprises. Fidelity Investments is working at the design school on stuff. They came and said, we have this problem, it takes 6 months to get startup pilots going. So then we brought in Y Combinator that's interested in this because it's efficient for their startups that are working on enterprise solutions to be able to get these things rolled out in weeks rather than months. Of course, we have law firms nearby that are interested in engaging with us at the law school and the design school. So we have a nice set of firms and departments, et cetera, all willing to work together to try to solve problems and look at them in new ways. So the point is that when we look at what some of the startups are trying to tackle, case law search, you see that it's challenged not just from engineering, not just from law, but the fact is that you have to have both. And as I spend time working with startups and trying to consult with them, time and again we run into problems where the engineers and the lawyers don't really know how to communicate with each other, and we need to bridge that gap more. And so some of the stuff that we're doing by training lawyers, not necessarily to build software, but to understand what software is doing and how to work with engineers in a more intelligent way. And that rolls out for law firms as well. So it's not just startups. How to work with big data, high quality procedures. I'm going to skip this example in the nature of time, but the main point is, even within the law firm, it's not enough that we train students to look at innovation within law firms. We also have to have an environment such that that's wanted by the law firm, for example. So who are those decision makers? How much are they learning? Can we create a pipeline for a different part of the profession that is the legal technologist? Okay, that's it. Great.
Thank you, Ron. When we talk about the use of technology more in law, one thing, of course, we're talking about is how can we more efficiently match consumers of legal services or potential consumers with the relevant expertise wherever it may be. Richard Granat has been a pioneer in doing this through e-lawyering, having pioneered the first virtual law firm. Let's turn it over to Richard.
Thanks very much. Well, I've got 8 minutes, so I'm going to have to really crash through this. The first thing I want to say is that with the cooperation of Will Hornsby, who's with us from the Standing Committee on Delivery of Legal Services, we did a survey of all 220 law schools to see what they were doing on the teaching of law practice technology. That's not the technology of law, but the kind of other new disciplines that we think are really necessary for the 21st century. And out of the 220 law schools, only 40 responded. And out of the 40, probably we kicked out like 20. Marc worked on this with me. And we ended up with 10 top law schools in the US, and we're putting it in an article. For those of you who are here from other law schools, you have to read the article to see if you're on the list. It's coming out in July in time for the ABA meeting. All right, so our assessment, based on empirical data, is that the law schools are very far from dealing with a lot of the issues that we deal with here, which is obviously no surprise. And I want to just segue for a minute on what you were talking about, which is business model. We've kind of done some mapping of the Christensen framework onto both law schools and law firms. And law firms still, the large law firms, are really designed on what we call solution shops with some exceptions. It's what Susskind calls still bespoke law, where lawyers can work on problems which are indeterminate and of great complexity. And as a result of that, the major resource are highly expert trained folks, and the billing method is going to be billing by hour. Unfortunately, the trend, the general counsels are putting pressure on all the large law firms to have what we call evaluated process model, where we have more routine transactions. In evaluated process model, you put together technology people, administrative checklists, and other procedures, and you have an input which creates evaluated output, and usually the pricing is fixed pricing, as we've seen Axiom doing this in Riverview Law. And those other institutions are beginning to, alternative institutions are eating the business of the large law firms for lunch. Now, when you go take a look at law schools, the law schools are organized in a way to produce lawyers around the solution shop model, not to produce lawyers who understand anything about this evaluated process model. Many solos and small firms have nothing to do, a very small percentage. This immigration thing we just saw, only 3% deal with tough solutions. 97% of the work is about evaluated process systems. So we believe those are the skills that people really need for the 21st century. So I'm going to go through this. There's obviously a confusion of business models. If you can't sort this out, you don't really understand where you're going. So what we did was, this is a part, not really a commercial, but a third-tier law school came to myself and Stephanie Kimbrough, who's in the audience, and all of their graduates were coming out and couldn't get any jobs. They were all going into solo practice. And we also know that large law firm employment is completely flat. The only growth is in alternative organizations like outsourcing companies and other kinds of organizations like that. And they asked us to build a curriculum for the 21st century, which could actually result in giving these lawyers some skills so they could actually practice law and make a living. So what we did is we took Suskind's book, Tomorrow's Lawyers, and when he talks about 13 disruptive technologies, and we converted it into a curriculum. So we built a course around each of the job titles that he begins to talk about. We call it the Center for Law Practice Technology, and I'm co-directed with Stephanie Kimbrough, who's sitting in the back. You want to raise your hand, Stephanie? I'll give you a shout out. Yeah, so she's written a lot of this. So we developed these courses, like training lawyers as entrepreneurs, the ethics of online legal services, which Will Hornsby teaches, document automation and expert systems, which Marc teaches, legal process outsourcing, legal project management. And each of those are going to become job titles in larger organizations, but you can also use these skills in solo practice as well in terms of pieces of them. So here's some other examples, a little typo there, but you get the idea. Actually, on legal process redesign, we're working with Andrew Baker, who's the Global Innovation Director for SafeArth. So we're going to build a core of courses, and more importantly, this is on a distance learning platform. So we plan to actually export it to law schools throughout the United States, because we have essentially a nationwide faculty. You can't find the faculty in one place. And it has really a worldwide impact. Like I have a school in China, law school in China, which has a JD program that's based on an American JD who's interested in having his students do this as well. So let me see what else we got here. So these are just some of the topics. Everything really is related to delivering legal services online, understanding that the internet is a new platform for delivering legal services and pulling out all those implications, trying to figure out new strategies for delivering legal services when you have a digital component which reduces the cost and the products of, for example, documents down to zero, how to really negotiate in that kind of environment. So we deal with pricing strategies, but also other kinds of deep dive into other kinds of sub-skills like document automation, legal expert systems, legal project management, so the students get out and they can link to their dynamic projects on their dynamic resume to demonstrate to an employer that they really mastered these skills. And if you want to see more about it, you can go to digital-lawyer.com, which is a dedicated site which describes both the philosophy and the curriculum and the people who are doing this. We think that these concepts eventually have to move to many, many law schools. It's one developmental trend which will have to happen in order for lawyers to be effective in the decades ahead. Thank you.
Great, thank you, Richard. One thing if law schools are going to start to train people in this area is not only to train them to be more conversant with technology, but also to think more entrepreneurially. And Janelle Orsi is a perfect person to talk about that and other issue with what she's done with the Sustainable Economies Law Center. Janelle?
Hi, everybody. I'm Janelle Orsi. I co-founded the Sustainable Economies Law Center. I've also been in private practice for the past 7 years, and my practice is focused on the sharing economy. And I also have 2 legal apprentices, which I'll talk a little bit about, but there's 2 people here in California who are studying under me to become lawyers without going to law school. So I draw a lot of cartoons because I like to visualize the future, whether it's good or bad, hopefully good. But here's an interesting piece of information, which is the ABA has said that the middle 70% of society, for the most part, is not getting its legal needs met. They can't afford legal services. So this is, well, first of all, it's a huge failure for the legal profession. But I was also, for a long time, I was like, just how are especially the top 20% of society, how are they keeping all of these lawyers so busy? And then I finally began to understand a little bit more about wealth inequality in the United States. And it's not that there's 20% of people keeping them busy, it's their wealth and their assets that lawyers are managing. And that's why so many lawyers are able to make their livelihoods by serving that sector of society. So it's kind of like lawyers are just all over this mass of wealth. And, sorry, just for emphasis. And I think that we all know this wealth is continuing to flow in that direction. We really need to reverse it, or things are going to get really bad. Things are going to get really, really bad. So the good news is that there are solutions. What is the opposite of an apocalypse? A co-opolypse, or sharing economy. I don't know, there's so many different words and phrases floating around in the world right now. Resilient communities movement, cooperative economies. But yes, it's economies where every community has people coming together and forming projects, harnessing the resources in their communities to form worker co-ops and housing cooperatives and basically provide for themselves. And there are so many things happening in the world right now that demonstrate that this is a movement. Beautiful things. And the great thing about worker cooperatives and housing co-ops and food co-ops and all these things is it circulates and recirculates wealth in the communities that are engaging in these activities. So it's not that we need to reverse the flow of wealth back in this direction necessarily. We just need to grow the wealth through economic activity for the other 80%. And transactional lawyers are going to be needed for this, tons of them, because what we're going to be doing is creating a lot of new organizations, new agreements, car sharing agreements, bylaws for cooperatives, and so on. And that's what transactional lawyers do. And I never thought that if I wanted to create a better world that I would become a transactional lawyer, because I read that the majority of transactional lawyers are greasing the wheels of really big corporations, and those corporations I knew were destroying the planet and destroying communities. So I never thought I'd be a transactional lawyer, but then it now makes sense that if I want to recreate a new economy, now I'm a transactional lawyer, and I'm greasing the wheels of organizations and activities like this. And 700,000 is kind of an arbitrary number. I don't know if that's roughly the number of transactional lawyers in the United States, but we need to create this new economy because it's just going to make our world a much better place. And it's not just transactional lawyers. It's a lot of transactional lawyers, but also there's going to be litigation in this realm. I know you're probably most familiar with the litigation happening around Airbnb and TaskRabbit and Lyft on those sharing economy companies. But there's so much more. And we also need to create new policies at every level of jurisdiction. And we need to teach law students how to do this work. So of course, law schools everywhere are scrambling to establish curriculum to focus on this. Not really. One thing that indicates to me that law schools are kind of slow to come around to needs is that this is how many unemployed lawyers there's expected to be by the year 2020. And of course, 55% of last year's California law school grads still don't have full-time jobs. And law schools are still not teaching students how to start and run law practices. So that's just, it's just embarrassing. And it's just terrible that law schools are not empowering people to do this. But there's so much potential to do this, for people to go out and start their own law practices, and the potential is right there. It's the 70% of people who need legal services. The demand for legal services is there. There's supply, meaning lawyers who could serve them. There's just an artificial scarcity because we haven't been willing to bring the legal profession back down to earth enough to serve that portion of society. But we have to serve that portion of society because I think that 70% is going to create a better world. They're the majority of workers, the majority of consumers in society. They're the ones who are actually going to take the time to create projects like this. So, and there's also very few lawyers doing this work yet, but there's an increasing number. The ABA published my book, Practicing Law in the Sharing Economy, so I've been hearing from lawyers all over the country who are now turning their focus on this. I used to call myself a sharing lawyer. Now I call myself sharing economy lawyer because people take it more seriously. But whatever you want to call it, every community in the United States needs lawyers who are embedded and working with community members to create these projects. And law practice looks really different than it used to, and that's why it's going to be doable. If you kind of deconstruct it, like a law firm doesn't need a receptionist and a fancy phone system or even, name on the door. You don't even need to get all dressed up. You don't need furniture. You don't even need to wear a suit. Here's what happens next. Really, this is what I look like when I'm practicing law. It's very low overhead to start a law practice these days. Really, all you need is a client for the most part. But anyways, and of course, the cost of law school is going up, which is crazy because law schools are continuing to assume that law students are going to find it, worth $150,000 to and to go and pay their law professors like $300,000, $400,000 a year, which is what I know some of the professors at Berkeley were making, when so much is happening in the world that we should be really concerned about. So I'm not really prioritizing paying off my law school debt when I know that Scientific American has said that around the time I pay off my debt, the world fish populations will be largely depleted. And so I'm going to focus my attention on things that are destroying the planet right now. I'm not going to work really hard to pay off this huge debt. And I think a lot of people are recognizing it's just not worth it to pay for law school. So here's what, oh good, it's working. So here's what my coworkers and I are doing. So there's 4 non-lawyer staff at the Sustainable Economies Law Center. And so they're all apprenticing with lawyers to become lawyers without going to law school. It's a 4-year process. You have to study and work with a lawyer 18 hours a week. You have to take a monthly exam. You do have to pass the bar exam, but it's doable, and we're loving it. And I just threw up this boring slide to show you that you can go up on the State Bar's website and learn how to do this and what the process is. Not a lot of people are doing this right now, but we are getting just a wave of interest of people wanting to do this. It's just driving us crazy how many emails we get every day. And it's not like we can help people do this. They need to go out and make this happen on their own. But anyways, there's an incredible amount of information out there for our apprentices. So many free online courses that I don't feel like they're missing out on the academic component of law school that much. There's of course the interactive and service learning components of law school, and we've created a living classroom for that. So last year we advised 224 clients who are local projects and enterprises, and our Resilient Communities Legal Cafe is the name of the program. And we set up a space just like a cafe, sometimes in an actual cafe. We have law students doing intake, we have apprentices doing intake, lawyers giving advice to community members, and there's just a flow of information going in every direction around the room. And this is the new living classroom. And I think it's giving our apprentices a really rich experience, but it's just one experience. The thing about legal education is we can just start from scratch and re-envision it in so many different ways, and this is just one of the ways. And I think we need to create a strong culture of learning and sharing in the legal profession in general. We created a currency to incentivize lawyers to share information with each other rather than withhold it and pretend it's all really difficult. So we might start accepting this currency called Halo, helping another lawyer out, for our CLEs. But anyways, because there's so many clients, we want clients to have as much access to lawyers as possible. So in the moment they think, I want to start a cooperative, they get the legal services they need. There's so much work to be done to break new ground, create new legal structures, replicable models. And anybody who enters this field right now is inevitably going to be a leader in this field because there's so much work to be done. Every client is probably going to be something that hasn't quite been done in the same way before, so that's breaking new ground. So in sum, I think that things are going to change very quickly. At the very least, my goal is to get 100,000 lawyers to focus on this in the near future. I have hope that that's really possible given that there's going to be roughly 300,000 unemployed lawyers, so they might as well be doing this. Law schools should definitely be teaching people the skills and the areas of law that are needed to do this, and I think that lawyers are going to be a lot happier because that's another key thing to remember is that we're also human beings, and I think we do want to love our work at the end of the day. So there's my book. There's a discount code for it, and that's about it. Thanks, everybody.
I think we also have to teach our law students how to make cool pictures like that as one of the skills. Turn it over now to Richard Granat. Sorry, not Richard Granat because he's spoken already. Marc Lauritsen, sorry. Many of us are relatively new to this field of legal technology. Marc's been pioneering in this area for a long time through Capstone practice systems and a number of other initiatives. Marc?
I'm not going to be able to compete with those slides, I'm afraid. A couple questions for the audience. How many people here are in law school or went to law school? Looks like 90% or plus. How many took a course in which you studied the rule against perpetuities? Pretty much the same number. How many took a course in which you wrote software applications as part of your coursework? Wow, I've got maybe good. 10 people. That's very encouraging. A year or two ago, you would definitely get 0. So I'm going to talk about this idea of courses in which that happens, where the part of the assigned work is to actually build something that's a useful artifact that does non-trivial legal work, where you're drawing upon the ideas from clinical education of experiential learning, but rather than just doing things, you're making things that do things, okay? And also drawing on the notion of learning by teaching. But here you're teaching a resource that is blazingly fast in computations, has a prodigious memory, but has very little common sense, doesn't make eye contact. It's kind of like having Rain Man as your paralegal. Instead of this autistic savant that you're trying to impart into it some knowledge about how the law works so that it can go forth, or he or she can go forth and help other people when you're not around. So you can expand access to justice. So you can think of 3 contexts in which applications of this kind might be built. One is for use by an advocate or a professional in a traditional service arrangement where the client is not participating in the technology. It could be in a situation where there's co-production, where both the client and the lawyer or the professional are doing things in relation to technology and with each other. Or it could be in a mode where you're building an artifact, some sort of device that you're putting out into the cloud for other people to use to get their legal needs met, but there's no contemporaneous interaction between the author and the consumer. And that tends to be the majority of the kinds of applications that these courses do. Briefly, there's a long list of potential knowledge objectives and skill objectives these courses can serve. I think one key one is just acquainting mostly non-programmers, folks who've had no experience whatsoever with software, with the nature of the software development process. What's an algorithm? What's a data structure? How do programs work? What actually goes on? Can I do it? right? What aspects of legal work are amenable to being modeled in artificial systems, and what aspects of legal work should be modeled, right? What are the ethical, regulatory, policy dimensions of this? So it's very rich. For me, one of the most exciting parts, though, is this self-discovery, where folks who generally have seen none of this in their career all of a sudden light up and discover new interests and talents and capacities, or confirm that they don't have any interest in this. But it's a whole new way of seeing yourself. Plenty of skills. I think the most interesting here is really design thinking. Being able to imagine a process of engineering a useful artifact that's going to be used by somebody downstream that you're not controlling. You need to think ahead for a whole category of circumstances where someone's facing an eviction, where someone is trying to get an order of protection against an abusive spouse, or you're doing some form of immigration work or bankruptcy or welfare benefits. How do you design something that accomplishes that task in an effective way, a usable way, that fits into a system of delivery that's meaningful? And there's plenty of other things you can learn in this process of doing a project. So the motivations really for students are gain some new insights into the nature of lawyering. What is this? What's the phenomenology of lawyering? What do lawyers do? What's this process? What goes on in our heads? Is it really information processing, or is there something deeper? To what extent can this be modeled in software? Can it be effectively captured in an artificial system, whether it's artificial intelligence or artificial intelligence, as I heard this morning? But on a practical matter, being more marketable, having a new edge for your potential career aspirations, and being a better informed consumer of technology as you go forth into the world of practice. The payoffs for students, learning, career positioning, for the eventual lawyers, more career satisfaction, more effective practice, more opportunities to engage in positive impact on the world. Society, as you deploy more and more of these kinds of applications, expanding access to justice, achieving more of the rule of law. And for law schools, really an opportunity to resuscitate the value proposition across these different aspects, right? Where you can serve society at the same time you're serving your students and serving the profession, opening up new connections with the profession and with the emerging, growing legal technology industry. So one form of this is something we call apps for justice, which are courses that are explicitly designed to build modules that are designed to serve the 70%, the folks whose needs are not met. Practically speaking, we generally use, and I say we, it's Ron Stout and I and Danina and other people in the room, we generally use application development platforms. We're not teaching students how to write in C# or Python. It's tools that are accessible to somebody who has no real programming background, but they can express their knowledge. A to J Author is a very good one, has this kind of a graphical programming environment. You can use document assembly tools like RapidDocs and HotDocs, other tools. I should say this is really not a new idea. There are at least 2 law schools where this has been going on since the late 70s. Ron's school in Chicago and Brigham Young in Utah. I got inoculated with it myself when Larry Farmer from Brigham Young visited at Harvard in the mid-'80s, and I kind of acted as a TA for 3 episodes of his course. We were building on VAX mini computers back at that time. But Paul Brest here at Stanford had a course on legal expert systems where students were building applications as I understand it. Northeastern had a long stretch of Don Berman and Carol Hafner doing AI and law seminars. Up at Franklin Pierce in New Hampshire, Hugh Gibbons was doing stuff on the Mac. I spent a semester having students build hypercard stacks in the 80s. So then there was, in recent years, there's been a second round. Columbia has had a course on law in the digital age, and they're starting now also to have students build applications as part of that course. Tanina Ronstadt and her colleagues at Georgetown have got a great program. You probably heard about it. It culminates in the Iron Tech Lawyer competition, where students build expert systems as teams and then go forth and have a competition. I've taught a course at Florida Coastal with one of Richard's colleagues. I think Judson Mitchell is here from Loyola. So it's starting to grow. And thanks to Ron and his colleagues largely, there's a whole new cohort of schools that are coming online that are trying to model this notion of courses where you build applications aimed at access to justice to expose students to these issues. So they can be done as part of this access to justice focus. I do more of a survey course where I use this as a foil to explore issues about the implications for the profession, the nature of legal reasoning, the societal and the political issues around them. You can do it more vocationally, which is the Florida Coastal kind of a for-profit law school model. You can have things be document generators or expert systems, or they could even be games in some contexts. They can be done in person or at a distance, have projects done by teams or by solos. They can be associated with competitions, incubators, or accelerators. Not without its challenges. It can be very teacher intensive, and there's a sense that we have kind of a shortage of people that are able to teach these courses, which I think is overblown because almost any competent lawyer and law faculty member could learn enough about this to do the course well. You don't need to be a deep programmer to do it. You just need to stay a few steps ahead of your students. There's a tendency to overstuff these with too many agendas. We have to, at some point, just slow down and say, this is all we're doing in this course. We're not going to dilute it. There are logistical challenges of finding useful applications, so you're not just making up toy applications. And that involves having domain experts who can give input and test and participate, et cetera. But one challenge is academic responsibility. At a lot of law schools, I think a course like this is regarded as the equivalent of shop class in high school, right? Where the less gifted students go to play with wood, you know, and the tools. And so I think you have to demonstrate there are, in fact, legitimate jurisprudential, historical, policy, deep analytical questions and important issues. So, to wrap up my last slide, it's a lot of fun to teach. I've done it now twice. I'm doing it in a couple of different versions this year. And routinely you get wonderful student reactions. Like I always hear everybody say, everybody should take this. And they come in and they go, wow, this is the best thing I ever saw. This is an extraordinary course, one of my favorites. I no longer feel like technology is something I cannot learn. A lot of people say, I really hesitated coming into this course. But boy, I amazed myself with what I produced. So. For those of you that are at a law school or are associated with one, I really encourage you to spread the word and try to get this kind of course at your school.
Questions? Comments?
I apologize for just walking in, but I'm curious if you addressed the question of how do you battle the rights orientation of law school faculty that sees these kinds of initiatives as something less than pure, and how do you innovate in the curriculum if you've got a law school faculty that ultimately says grace over it all?
Yeah, so we just went through some of those battles to get these courses approved because they have to be approved by the faculty. It can be difficult depending on the school. You need strong leadership from the top. If the faculty feels endangered, that's a motivation. It usually requires other faculty. So if we're teaching some of these practice management and technology skills, it doesn't necessarily infringe on their area because it's not doctrinal substantive law. So they actually do feel less threatened. When you begin to talk about integrating technology in their doctrinal courses, like, let's use a spreadsheet in estates and trusts. All of a sudden they get real nervous about that because they feel that you're encroaching. But the answer is really a strong leadership from the top and a vision of where the school has to go. It really gets down to that. You can't make a move without really powerful and strong leadership who can knock heads together and make it happen.
I think another argument is Can you hear me? Another argument is just looking at the profession and the employment records of the students, and at some point something has to change. Law schools know it, and increasing somebody's effectiveness and likelihood to get a job and kind of moving towards the changing profession has to happen.
Yeah.
So I think that's hard to ignore. Why do they ignore? I'm not sure that they do. Example is like if you look at Christensen's Innovator's Dilemma, and he's using an example of hard drives in that industry. You know, if you weren't building your disks, you had 2 years and you were dead, right? If you didn't catch that. Law moves a little bit slower. So when we're looking to see, it's like, what does it look like when let's say a snail is really going fast? So I'm not sure. that law schools aren't moving as fast as they can, and then you have issues around the ABA limiting how much you can bring in adjuncts, et cetera, so that we don't have a history of this training, and it's cross-disciplinary. So there's issues around getting people on board, and then you add to that the fact that people want to have, like look at a school like this where you pretty much need to come from another elite school in order to teach here, but the elite schools haven't really taught, so you're kind of bootstrapping. So there's a little bit of issue
There's
there.
some questions on the right here we should probably get on.
Yep.
Yeah.
Change for law schools. To say
Yeah,
that
that's
law
correct.
schools can't change and innovate is a fallacy. And we need to look at the historical data associated with that, take the lessons, and start applying them now. That's it. That's my
Agreed.
statement.
We agree. Yeah, we agree. We're here. We agree.
I could take a class on machine shop, and I wouldn't be qualified to go out and be a mechanic. Heck, I could finish my 3 years of law school and probably not be qualified to actually practice law. To what degree does the limitation of one course or without subsequent follow-up, or the fact that there may not be the type of apprenticeship roles once we do graduate in this sort of new emerging field, affect how you view what we should be doing with our legal education to potentially mitigate those problems or give us the type of hands-on experience that can allow us to transfer limited skill sets to larger domains and to new problems?
First of all, law schools are now innovating by creating incubators, which are transitional entities to help people get acclimated to practice and get mentoring and tutoring. Something like, Will knows this more, 25 law schools have incubators, but I think that's going to roll out to a much larger percentage. It's one solution, it's not a total solution. Anybody got other ideas?
I'll just say we're at the early stage of the process. So eventually you'd like an entire infrastructure built around this new attention to new technologies, new modes of practice. But I'm happy to start with an occasional course. That would be progress.
There's a connection between the technology and what was usually called previously law practice management. That whole subject matter has now changed because you can't talk about law practice management any longer without understanding technology and how it reshapes the delivery of legal services. They're really very much integrated. So that calls for new content, new courses, and a change. And I think you're quite right. There was really major innovation with the legal clinic movements, and we're kind of optimistic that in the fullness of time this will spread. Yeah, do you think?
I agree.
Yeah.
I also wonder to what degree we're seeing a sea change because of the handling of first-year associates not being an apprenticeship as much, not being training grounds. So, when you look at medical school, what do they do in the 4th year, or they are expected to go to do a residency program, and where is the equivalent of that in law? Was typically we kind of thought of that as maybe a big law job, but of course big law doesn't work for most students, most schools. So I do think it's kind of interesting to think that maybe a 3rd year of law school, which has often been questioned as whether it's necessary, really is the time to train people to do hands-on practical work. So.
Mm-hmm.
First, follow on with the comments you just made and the series of questions I'm taking up chances of having on repitching my question from lunch with a few with an incendiary or two. I've heard it said before, there's a comparison between Germany and Austria. They said in Austria the situation, in Germany the situation is serious but not hopeless. In Austria it's hopeless but not serious. So what percentage of schools does it matter? That's one thing. And then this discussion of changing law school to 2 years instead of 3 years, should still be a doctorate degree then?
I'll just mention, there is in medicine, for example, a difference between a medical degree, which is considered a professional degree, and a PhD in medicine. And I often look to see where we might see more PhDs in law. There is a JSD program often, like at Stanford. And so is it a doctorate? Is it a doctorate in medicine when you don't have to write a dissertation? It's still considered, a doctor. So, I don't, that's just kind of definitional more than anything. But I certainly personally feel there's plenty of room for a PhD program in law, and I'd love to see that a little bit more.
Those are academic degrees, not practice.
That's right,
degrees,
academic degrees. What was the other part, 2 or 3 year?
How many of them are embracing really? I think the 2 year, 3 year doctor, that's one part of it, but also just whether the school should we care about.
Yeah. Why should schools really care?
Should we care whether schools survive or not?
Well, a lot of different aspects there. I'll just say one thing, which seems to me, people in this room recognize, I believe, that the rise of non-biological intelligence is going to be probably one of the dominant developments in our lifetimes in terms of impact on the profession. It's already hitting us, but if we're at the elbow, as Dan said, we're about to make a turn, and it's going to get radically faster, scarier for a lot of people. So I think law schools that ignore it at their peril. It's the next 10 years, if you're not doing some of this, you're actively disserving your students.
My question is about the different ways of thinking of what we think of as lawyers and engineers. In my experience working with both and projects over the last 20 years, I've noticed that lawyers have they view reality very different ways. In engineering, there's cause and effect, physics, and in legal thinking, everything is possible in a way. There is no reality, and it's persuasion. It's about persuading and changing people, either the judge, your adversary, your client. It's always persuading. So I'm just wondering, in this fusion of the two that's happening here, is it still important to keep that legal persuasion skill, the rhetoric, and that skill strong? And how are your courses? How's your vision of the future? Where is the role of that rhetorical capability?
You answer.
Well, my quick response would be, I think, again, by paying attention to how you can model legal reasoning and legal behavior, like counseling and advocacy, in software, you're forced to deconstruct it, to understand the nature of that cognitive activity. And so for some students, that gives them a new window on what they're actually doing, and it can enhance those skills. So it's not a substitute, it's an enhancement to me, a new way, a new kind of an instrument through which to approach the traditional lawyering skills.
Yeah, advocacy, negotiation, persuasion, those are still core skills. And we're talking about another complementary set, another way of thinking about the way in which legal services get delivered, particularly as they get digitized. Because once they get digitized, and you need new combinations of people, software, and so forth. So one really complements the other. They're kind of not mutually exclusive. They're just different. They're different, right?
I think the notion of persuasive to an electronic judge is captivating. So what persuades an automated system to go along with what you're saying is going to be very different than what would persuade a human. And it's not that we're moving to electronic judges, but the notion of reasoning is going to probably change a lot.
I think let me just add one variant on an answer to that is, back to Dan Siciliano's thing from immigration law, which is you have this 3% kind of work at the top that's still going to be for humans and lawyers and is going to make a difference in outcomes, and then you have the 97%. And one question is, what percentage of law school training ought to focus on that top 3%, and what percentage ought to focus on overseeing and having an excellent process for that 97%. And that, of course, might vary, may not be the same percentages for immigration law. It might vary depending on where the school is in the food chain, et cetera. But that's sort of another way of thinking about that issue.
One more point. Let me just say that there's a concept of enabling lawyers to operate on what I call at the top of their license, what they were really trained to do in law school. But in order to make that happen, all the things that could be delegated to software, other kinds of staff, paralegals, that model, the immigration model, I think is very instructive. So you should really design systems so that lawyers really work at what they're really trained to do, not do all the other tasks which they're not trained to do. That obviously may mean that there's still less demand for lawyers, but that's another issue. But I think your question is, in a law school, how much do you devote? I think it depends on the law school and who the law school's clients are. I mean, Stanford is very different as a place where most of the people who graduate here will probably still fit into that job shop model where they're dealing with indeterminate problems, and that's a good thing to happen. But the other 2/3 or 75% of law schools, we're training those law students for this job shop model, and it's totally irrelevant to the reality of what their practice is. So there's something very wrong about that we're training law students for jobs that they're not going to fulfill or do. They walk out, and the reality of what they have to do has nothing to do with the training that they got, because they were being trained to be Supreme Court clerks by their faculty, but none of them are going to be eligible to become a Supreme Court clerk or even be hired by a big law firm. So this disconnect is actually fundamentally unethical and fraudulent, in my view. Right? So.
On that note, last question.
Okay, now,
I agree with that completely. This might be a way of just restating what's already been said, but following up on Jonathan's point that in 3 years of law school, apparently you don't even learn enough to actually competently practice law. If you combine that with an untested hypothesis I'll make, which is that each year twice as much legal work will be automated as the year before, is there a need for JD degrees at all at this point?
Probably. Yeah.
But why? If you're not qualified and the
We're out
work
of
is
time.
going away, what is the point?
You always ask these tough questions, Aaron. I don't know. I can't.
I mean, well, one way to address that is, Janelle, I don't know if you have enough experience at this point with the apprentices to have a rough sense of, do you think they're going to be as well trained, maybe better trained, to practice law, having not earned a JD degree?
I guess one thing is when I graduated from law school, I had no idea how to form a corporation, and that was the first thing that I had to do. So, but my apprentices have already done that multiple times. So yeah, they're ready to do a lot of things, and I feel like I can rely on them. They would be the first people I'd ever hire. In fact, I already have. But I think that legal education is just going to be widely customizable at this point. People can put together some classroom learning with some practical learning. Now, this is in the states where you can combine things, which is only 5 states right now, but I've been getting emails from people in Oregon saying, how do we get Oregon to enable people to become lawyers and with more diverse legal education scenarios? So apprenticeship plus legal education. So I just think that every person's different, the way they learn is different, their goals are different, their clients are going to be different. And so legal education should just be wildly variable.
Yeah, that's good.
All right, thank you to our panelists.
Thank you.